Join former FBI senior forensic examiners Becky Passmore and Stacy Eldridge as they dig into the world of digital forensics, one bite at a time. Now leading their own consulting firms and educating the next generation of cyber sleuths, these badass babes of digital forensics bring sharp insight, real-world case experience, and a dose of humor to the bits and bytes that build today's investigations. From deep dives into business email compromise and ransomware attacks, Becky's specialty, to cracking the complexities of iPhone forensics, Stacy's obsession, this podcast delivers insider knowledge for professionals, students, and true crime techies alike. If you've ever wondered what really happens when the digital trail is all that's left, tune in and start parsing the truth.
Welcome back to Parsing the Truth One Bite at a Time. And this week, my co-host Becky Passmore and myself, Stacy Eldridge, we are going to be discussing expert witness testimony. And we are doing this as a lead-in to a lot of the other episodes that we're going to be doing, because in all of those, we're going to be talking about what the experts said when they were testifying in digital forensics or mobile forensics. And so we wanted to give you a very good foundation of what it takes to become an expert witness and all the things that are going on in the courtroom that maybe nobody has ever explained to you before. Now, if you're in this for the digital forensics part of it and you haven't testified, this is going to kind of give you some inside knowledge of what it's going to be like. But if you're into this from the true crime side of it, then I think we're going to give you some of that behind the scenes information that maybe you've always wondered about. So to kick it off, Becky, do you want to start us off with why we have to come in as experts and provide that expert witness testimony in court for these digital forensic matters?
Right. Absolutely. Thanks. Glad to be back for next episode of Parsing the Truth, One Bite at a Time. Yeah, when we're talking about forensic examiners as expert, providing testimony, they can provide it as an expert witness, and then they can also provide it as a factual witness. But the evidence has to be brought in by the person that did the work. So you can testify based on someone else's work, but you want to be able to review that and have the same knowledge and skills and abilities to do the testimony. But being able to, part of digital forensics, the forensics part of it, is the chance that it would make it into the court of law. I mean, forensics is about how it gets into the court of law. So having expert testimony provided by digital forensic examiners is crucial in investigations, and it's their responsibility to talk about what they did.
Absolutely. Now, there are different types of witnesses, and the other one I want to compare us against is the person who is a fact witness. So as a fact witness says, they're just stating the facts of the matter. But now, right. Becky, as an expert witness, what can we do that fact witness cannot?
Yeah, we can be able to, we're able to provide an opinion. So if you think about digital forensics and the fact that there's different pieces to the puzzle, and you might not have every piece to that puzzle, and you need to fill in some of those blanks, and you're able to analyze the digital forensics, you're able to apply the attribution, profile the individual based on what's on the computer, then now you're able to provide, based on your education, your experience, and your training, now you're able to provide your opinion. And that's the difference between, that's one of the differences between a factual witness and an expert witness.
We have to be able to draw those conclusions first and then state our opinion about it, why we think that this happened, or maybe we're going further out and we're saying, and we think this means that. And so, but every opinion that we give is going to be based on everything we know about the case. It's not like a personal opinion based on our emotions and feelings about something. It's still rooted in the fact of the matter.
And it's definitely not based on assumptions. So you don't base any of your testimony, you're assuming or filling in the blanks, you're basing it, all your testimony is based on the analysis that you did in the forensic investigation, and then pulling it together and being able to communicate it.
Right. And one of the other things we do as an expert witness is we are trying to get the evidence into the trial. So if you've been watching things, you've seen the lawyer is going to start to ask you questions about something. It might start off with, do you recognize what this is? Can you tell us about that? And then it normally ends with like, I would like to admit this as exhibit 1 to start off with. And then they go down through the numbers and every side gets exhibits. And all of those exhibits are created from evidence. And so all of our exhibits are going to be based in that digital evidence. Now, these days, courts are getting better about, showing more things on the screen. But even if it comes from digital evidence, it might get admitted into the exhibit as a piece of paper, or maybe it's a picture that has been added to a PowerPoint presentation and stuff like that.
Yeah.
And one of the things we have to do to get the evidence in, to get the exhibits in, is follow the rules of evidence. So Becky, do you want to kind of talk about some of the must-know stuff about rules of evidence and maybe touch on the consequences of not following the rules?
Right. And part of the rules of evidence is going to be discovery, right? So whatever you produce, it also has to go to the opposing counsel, get the discovery of the results, or they have their own expert that they will share what they have completed as well. So the rules of evidence allow these evidence items to be introduced into court through the person that handled them. However, there could be some stipulations to the evidence.
Oh, yep.
There could be
Stipulations is a good one.
Right? Inadmissible chances that the evidence never makes it into court. And then there could be times where the evidence is suppressed. And so when we're talking about evidence being suppressed, it's not making it into court. It's not being introduced. It's been deemed inadmissible for whatever reason. Maybe the chain of custody, there were some problems with the chain of custody, so they're not going to allow it to be admitted into court. Or many times, like you and me, the counsel will stipulate to our reports. They'll stipulate to what we did, because if they stipulate to that, then they're able to accept the work, and we don't have to testify on behalf of that.
Yeah, and I would say 20 years ago, it was especially common for the opposing side to just agree to concur with everything we said in our report. So we really didn't have to testify a lot. And that's our experience, at the FBI level as testifying in federal court, because we're working federal cases. Now, our coworkers who worked at the RCFL, who would work a lot of state and local cases, they tended to testify a lot more just because, for whatever reason, a lot more state and local cases seem to go to trial. And I don't know if that's because of the preponderance of evidence that is required to really even kind of start that FBI investigation. And as you get so far along, a lot of people just, take the plea agreement when it is a federal case. And that's at least, I'm talking like 10 to 20 years ago in terms of us either having to testify or not testify because they've either accepted the plea agreement or they, stipulated and agreed that everything we did was correct and right, and they don't have any disagreement with it, and they don't want to question us about it either.
That's right.
Now,
so that
some of the
I'm sorry. So then another part of what you're referring to is your state and locals that might go in and testify that worked at the regional computer forensic labs on state and local. Their testimony many times might have just been factual testimony, like they were a fact witness. They were there to have that item introduced into court, and they were there to talk about the facts. And maybe on occasion they would do a more expert witness testimony. And it's going to be your people that are more doing the analytical work as opposed to the just extracting of the evidence.
Right. I would say, yeah, you're there to talk about the facts of the matter, not so much, you image the hard drive correctly. That's not sort of the thing that tends to be in question when you are going in for that testimony, regardless of where you're testifying. And I would say that's even more so now. I mean, unless you did screw it up. I have a case where there was some mishandling of evidence. And that is one of the things, like you mishandle the evidence, you alter the evidence, people aren't signing the chain of custody and stuff like that. That can get tossed out before it even goes to trial. So there's like all these little, I'll call them mini trials. Hearings is the term I'm looking for, that they have before the big trial involving all the witnesses. And that is sometimes where they get those stipulations from. And that's where they say this evidence is going to go in or this evidence is not going to go in. And so then you have some kind of idea of some of the evidence. And I've certainly worked other cases in collaboration with another office, and some of the evidence didn't get in for a variety of reasons. And one tricky example is always those consents to search. So that's another thing that has to be handled with kid gloves if you're going to try to get that into court to testify about it.
That's right. And I, too, am very much like you, where they've either stipulated to it or there was a problem with the chain of custody or a problem with how the evidence was handled before it even got to me. That then they realized very quickly that they were going to have to go through battles to get it into court. And so instead, maybe they worked towards trying to accomplish a plea agreement versus, going to trial and having to discuss, a mishandling. Not that it was negligent mishandling, not on purpose. It's just that sometimes maybe a document didn't get signed like it should have gotten signed, and therefore being part of the chain of custody, being part of the search, being part of a process, just don't want to have to communicate something that would have been negative, but not negligent.
Right. And 100%, I will tell you that we are speaking to this from our experience testifying. The lawyers that go to trial all the time, they could tell you a million more things about how all of this works. But Becky and I like to think of it as a dance. There's some dancing going on in the hearings about getting stuff in and getting stuff tossed out. And then there's certainly a whole lot of fancy dance moves going on in the courtroom during the actual trial. And sometimes I think we are really kind of far removed for it. And I think that that's good in some regards, because I think it makes us a little less invested in the outcome of the case. It helps us remain neutral, but then sometimes it's like, well, gee, I wish I would have known X. Maybe I wish I would have known it got tossed, or I wish I would have known we can't talk about this sooner rather than later, because at the end of the day, you are helping to build the case and whatever is going to get discussed in court. And it's not like you as the examiner get to write a little speech about it. The lawyer is going to ask you the questions about anything that you're doing. So we don't have free will to say whatever we want. There are no monologues.
No monologues. None. Yeah.
Now, one of the other things to be concerned with during the trial and your testimony is speaking to the jurors. And one of the things you have to consider is the average age and education of the juror. And I think there's probably a difference on numerous levels in terms of 20 years ago and today. Becky, do you want to kind of walk us through some of those concerns about the jurors?
Yeah. So back when we were going through training and getting into how we were expected to testify, it was communicated to us about the average juror had an education of the 8th grade. So back then, cell phones were very new. Technology was somewhat new. Everyone didn't have a computer. Everyone didn't have a cell phone. The terminology of what we were using on a regular basis, even the word internet or web browser or hard drive or forensic image file, all those terms were very new to a lot of people. And so part of that process was being able to communicate in layman's terms, because based on the studies that the average juror had an education of 8th grade. Would you say that's going to be different now?
I think the average age, the average education level has probably increased a little bit with time, just because, we're 20 years away from that point, and the way people were raised and the access to public education has certainly changed over the past 20 years. But I think where we see the greatest change today is people's experience and familiarity with all sorts of different technologies. Certainly more experience with computers, being aware of the internet and email, and then with the phones, having more of that at your fingertips. They have more, just everything. It's inundated. It's unaware. And I will tell you, my father, who is a farmer and a carpenter by trade, he even finally got an iPhone less than a year ago. So, I mean, even he, a man who was like, I'm never going to use a computer, I'm never going to do any of this technology stuff, even he has jumped onto the iPhone bandwagon. So it's way more prevalent. And I think that makes it easier for us. What burdens do you think that reduces for us, Becky, as people have more of this familiarity with computers and cell phones and things like that?
Well, I think, again, it goes back to the majority of the people in the world have a cell phone, so they have an understanding of a cell phone, how it works, what they can do on it. When you're talking about surfing the internet, they might not understand what browser they're using, but they understand that. So where back in the day, 20 years ago, we would really work hard to find analogies and layman terms to discuss these more complicated technical words and processes. And nowadays, I feel like we still would use analogies. I still use analogies on a regular basis. I used it in a class yesterday where someone had asked a question and I just used an analogy of a backup versus a incremental backup, just giving them a background and using an analogy even though it was a technical one. So I think we would still use those analogies today, not as much that we would have to be concerned with them, the jurors or the personnel that we're communicating the results to having a less understanding because of the familiarity with, like you said, the use of computers, the use of email, the use of cell phones. But I think another piece that we have to worry about, Stacy, is effects of CSI shows.
Oh, yes, CSI. That show has been ruining digital forensics and police work really for at least 20 years now, ever since that show has gained popularity. What is the CSI effect, Becky?
That everybody thinks that case can be solved in 45 minutes and testified to and put to the bed with a verdict and everything else.
Right. Those shows give people the expectations that everything's going to be wrapped up all neat and tidy with this nice bow. But then the other negative impact of that show is jurors' expectations.
Exactly.
And now that I do defense work, maybe this can come in my favor, people thinking law enforcement didn't do enough to prove their case. But then I also think it still hurts on the defense side too, because then they have all of these expectations of what you should be doing to prove reasonable doubt based on what they've seen on TV shows. And it goes into other shows too. One I'm watching recently on TV is Elsbeth, and that's a spinoff from The Good Wife. So this is kind of from the lawyer's perspective, but now Elsbeth is a lawyer working with the law enforcement. She has to go out on scene with them and make sure they're doing everything right. But like in every case, she's the one solving the crime. But, and it's kind of like it demonstrates kind of how a case is normally not worked. It demonstrates working kind of outside of the principles of investigation. And then it kind of always ends with a person confessing. It never ends with them going to trial and seeing how much of this stuff that she did would even be admissible. So it's just giving again to those misguided expectations of how all of this is going to go down, what they can prove, and how neat and tidy it's all going to look.
Right, and I agree with you. I will never forget my husband, one of his favorite shows was NCIS, and I think her name was Abby, and
oh yes, Abby, I've heard that one. Yeah.
She was the digital forensics person, and I will never forget one day, I don't remember who the main character was, came in and handed her a hard drive, and she goes, I will make a copy of that right now and get to analyzing it. And 2 minutes later, she was like, I found the smoking gun. And I said, I don't think that's how that works. And he's like, this is my show. Let me enjoy it. So... yeah.
Well, and I think sometimes that even leads over to law enforcement officers working the cases with this, because then they're like, well, okay, I understand it's going to take more than 2 minutes, but can you just give me any evidence of any crime? It's like, oh, sure, let me hit the find all evidence button right now for you and spit those results out for you.
Exactly. That's exactly how it does not work. Right. So yeah, I would say a lot more people are interested in true crime. Thank you for listening to our podcast. A lot more people are interested in investigative work and forensics work, and that's all great, except for when it comes to trial and it comes to the work that leads up to doing trials and expert testimony. There's a lot that goes in that many people don't even see and don't understand. I mean, I would even say the attorneys working countless hours to bring a case to trial, and they always talk about how difficult it is. So I have a whole lot of respect for them.
Certainly. In my experience, when something's in trial, like those lawyers on both sides are living and breathing that trial 24/7. I mean, they get a little bit of time to sleep, but that is all they are doing. I testified a few months ago, and those lawyers weren't too far from home, like an easy commute, but they got like an Airbnb and were staying like right there, super close to the courthouse, again, to like minimize how much time they have to spend not working on the case, because stuff comes up all the time during the trial, no matter how much you prepare.
Right. That's
so
right.
Speaking of preparing, I think this is a good segue into how do you prepare for that testimony? I think we've kind of alluded to this, but obviously we need to create reports.
Right.
So Becky, do you want to kind of talk about reports, kind of like the two types of reports that we're producing, and are you always necessarily making them thinking, oh, I'm going to trial, or kind of like, what is your mindset when you're making these reports, when you're done examining the evidence?
Right. So I would say I always put the findings of my report based on the scope of the request. So what was the request? Was it to analyze a phone, analyze a computer? Was it based on a specific crime? Was there specific evidence that was part of the leads that the investigators followed? So writing a report with the details, the findings, the locations, how you went about doing your investigation, your analysis of the data, whether you were on scene during the search warrant or you and had to do some type of memory capture or imaging or whatever the case may be. So a very full-fledged report. Even nowadays, you can provide executive summaries, especially if it is in result of an incident that not much was resulted from the analysis, but you still want to provide some type of findings report to show either nothing was found or a full-fledged report that produces full findings of everything that was found.
Yeah, and I don't know if it's the difference between what we were doing in the FBI or it's 20 years later, but in the FBI, like I never had like an executive summary. I do one now and I love them. And when I'm teaching, I'm always trying to stress like try to come up with like the top, depending on how big the case is and the evidence is and stuff, come up with like the top 5 to 10 things that the case agent, the lawyer, must know facts that they have to know right away, because these are the super important things. These are like your smoking guns, and they're each not a paragraph long. We're just talking like a quick sentence to give them like, oh my goodness, this is huge. Let me keep on reading and find out more about that. The other thing a report is going to do is document all the evidence that you looked at.
That's right. That's right.
And when we were writing our reports, we certainly didn't know if it was going to go to trial or not. But that is one of the things that is going to go for part of discovery. So you can't write it like it's that you don't think it's going to go to trial. You've got to write every single report like it might go to trial. That way they're all written at the same caliber.
That's right. And I can remember a time where I did complete a case, write a full report, and based on the information that was found, the case agent came back and asked for additional information that would lead to what my findings were if I could find more information on the computer that I was analyzing. And so that led me into, and we'll talk about this later on some other episodes, was unallocated space, where I recovered a lot more data in regards to that case. And so instead of changing my full findings report, I added a supplemental report. So being able to write an executive summary, write a full findings report, write a supplemental report, there's going to be different reports that will be introduced, and it's based on what you did at the time of the investigation and the analysis.
And we're always writing them with, you know, the case agents, the lawyers, the jurors in mind. It's not like a passionate report from myself to Becky, talking all the computer lingo, all the forensic examiner speak. Nope, we're not doing that. We're doing it for basically everybody else. So theoretically, anybody could pick it up and get the gist of it. Absolutely. And that's part of what makes it so long.
Right. And you're writing a story based on pieces of information that you know, and how you put that together with what your findings were. And so one prosecutor told me when I was really, really nervous about having to testify one time, he said, "You wrote an amazing report. It was like a book. You now have to go in there and tell a chronological story to the jurors, to the judge, to everyone in the courtroom, and you know the most about the case. So now it's just storytelling time." And I thought that was a great way for him to summarize, I wrote a book based on the findings. Now I just have to talk about it so that people understand why I wrote the book on the findings. And so I think going back to, you spend a lot of time, you spend an immense amount of analytical time in just trying to correlate what you know to the artifacts that you're finding, and now you put it together in a report, and now you just have to read your book and tell the story. Yeah.
And then in addition to that written report, we create a digital report.
That's right.
And what is the purpose of the digital report?
That's going to be based on your tool, right? So we don't base our findings on our tool. We base our findings on our knowledge and our artifacts. But we have tools that can display those artifacts. We have tools that can provide pictures or paths or contents of communication. And so what we're doing is we're bringing that to the forefront, and instead of millions of artifacts on a report, you're summarizing it, or you're bringing in with just the most relevant pieces, whether it's a picture or an email or a document. Those are bookmarked into our digital forensics report that we produce alongside our written report, which is our book or our storytelling.
And they work very nicely together. And depending on the case type, you know, if your focus is really on pictures, you're probably not going to spend much, if any, time describing the pictures in your report. You're just going to give some high-level information, maybe where they're found, maybe some dates and times. And then you're going to say where they're bookmarked, how they can find that in your digital report. And then the expectation is that they're going to look at that digital report. Because you've done these two things, you've already done a lot of the legwork in terms of getting the exhibits ready to go. And so as part of your trial prep, you know, you've done some of it 2 years ago, and now you're finally coming up to trial. So now you're going to start meeting with the lawyers and having that conversation. Can you want to kind of talk a little bit about how that works when you're meeting with the lawyers and doing some of that trial prep?
Right. And I always felt like that was a way for me and the prosecutor to be able to have a conversation. I know what I did. I know what and they tell me what they need, right? And it's based on what I have in front of me. So we would sit and have a discussion about the report. We would sit and have a discussion about the testimony. And it wasn't like it was a script. We never were provided a script, but we were provided some general questions of, we're going to talk about this piece of evidence. We're going to talk about this part of your report. Because again, when your report is anywhere from 10 to 30 pages long, the jurors are going to get that because that's going to be part of an exhibit that's going to be introduced into evidence. And so they can now read that report. But a prosecutor or a defense attorney are going to highlight very relevant sections or evidence that they want to get into court through that. So meeting with an attorney and having a discussion about what we are going to do when we get into the courtroom.
And now, one of the other things I've had to do is verify the exhibits, because sometimes what they do, they have their paralegals or administrative assistants make things, they take snippets of whatever we have, and maybe they're zooming in on one text message or one paragraph in an email. And so then you've got to go through and verify what these things are and where they came from and that they're still accurate. You can't just be like, I'm sure it's all right, because they're going to have you introduce that exhibit. And so you're under oath saying, yes, I know what this is. I know where it came from. So you're going to spend a lot of time, especially if it's exhibit heavy, going through and just like sitting in their office and going through all of that stuff and going back to your digital report or your written report and verifying that it is all true and accurate, because you're going to have to swear to that.
That's right. That's right. And it's more than just your report or, a document. It can be an actual computer. I can remember in my very first trial where the computer was sitting on the prosecutor's desk, and when she asked me the question about, is this a computer that you analyzed? And she brought it over to me. And the way to verify that was I had dated it. I had written my initials on it. I'd written the case number on it. And so I can verify that is my information that I wrote on the computer. And so that is how items can get entered into court and become exhibits. But like you said, they're validated and verified by the person that's speaking about them on the stand.
And so, Becky, part of what you did was you said, it's storytelling. And so there's generally some sort of order, rhyme, and reason to the order in which you're going to tell this story. And it's because you're trying to put a puzzle back together. You're trying to tie all the pieces together.
Yeah, absolutely. It goes back to, again, as expert witnesses, we can fill in those blanks with knowing information, having the experience, having the education, knowing whether or not someone was trying to hide something. And because of those tracks, we don't have the information, but we can show tracks of anti-forensics versus, having all the pieces to the puzzle. It's never going to be like that. You may be missing an entire computer, an entire cell phone, or an entire document, or there's just different ways. So we're always trying to put that puzzle back together. We're always trying to make sure we have every piece, and we're not always going to have every piece. And because we don't have every piece, as expert witnesses, we're able to fill in the blanks with our opinions.
And we want to do it in such a way, and hopefully your lawyer helps you do it in such a way that the jury is starting to also put those puzzle pieces together along with you. Right. So we're always looking at them, kind of seeing like the light. We're looking for the light bulbs to go off. We fear the deer in the headlight look in the jurors.
Right. That's right. So as we've been talking about expert testimony, have you ever been introduced as an expert witness?
Yes, I have, Becky. What about you?
Yeah, I have. And the part about being introduced as an expert witness, it comes through the judge. So it has to be proven through your education, your experience, your certifications, your training, your knowledge, your expertise, and all of that is credentialized up front. We call it our curriculum vitae, where they look at a resume, our experience, our knowledge, our education. And it just really prepares the jurors to have an understanding of our background. And so we will get asked questions up front about everything from, where were you raised?
Where'd you go to school?
Where'd you go to school? That's right. How far of education did you receive? What are your degrees in? So I would say absolutely. It's one of those things where we're going to be introduced as expert witnesses once we have established our credentials.
Right. And normally one of the questions they're going to ask you, I feel like it's towards the end after you've kind of laid out all the things why you're qualified. Then they kind of ask, have you ever testified as an expert witness before? And the first time, it's always going to be somebody's first time. That answer is no. And that's fine. And then the next time your answer will be yes. And the thing I'm trying to point out here is just because you've testified as an expert witness does not mean you're magically an expert witness the second time and you don't have to do any of this. You're still going to go through your training, education, and background every single time. And hopefully every single time you will continue to get admitted as that expert witness. But personally, I kind of like that they do this because I think of it as a nice little warm up to testifying. I don't know about you, Becky. How do you view it?
No, I do too. And it kind of sets the stage and makes you feel comfortable because I don't know about you, but every time I got up there on that stand to testify, my heart was beating 90 miles a minute and I was really, really nervous and I was a little shaky. So these softball questions,
yes,
getting to know you, making you feel comfortable, it really helps you to get your nerves calmed down. And then you're able to communicate your results without feeling like you're not as confident as you could be if you weren't, sitting in the limelight.
Yeah, you just kind of like ease into it. You kind of get the lay of the land and like using the microphone and where the jury is, where your lawyer is, where the other lawyer is, where the judge is. And I mean, sometimes you're super close to the judge. Sometimes they're really far away. And sometimes the courtrooms are in really awkward positions. And you're like, I don't feel like I can look at anybody. So you get to kind of try that on as you're introducing yourself. And talking about yourself should always be the easiest part of it. And that's why it's a nice warm up. If you can't explain why you're qualified, then you're probably going to have a really hard time testifying because it just gets harder.
That's right. It does. It really does. Well, we're about out of time, and our next episode, we are going to walk through Stacy talking about her first time she testified as an expert witness. And it's going to be very fun and interesting as we go through it. And so with that, I'd like to say until then, stay safe, stay sharp, and as always, keep parsing the truth one bite at a time.
If you've enjoyed this episode of Parsing the Truth One Bite at a Time, please head on over to our website, parsingthetruth.com, and click on that donate button and help us raise funds to send one future digital forensic examiner to the IASIS Basic Forensic Examiner Training next spring in Orlando.